Hi, I'm Russ Weninger. I'm a wills and estate planning lawyer in Calgary, Alberta, Canada. This may come as a surprise, but doing a will is only one part of estate planning. For many people, a significant portion of their assets is actually distributed outside of their estates. Today, I'm going to talk about some ways of distributing assets outside of a will. Often, people are interested in distributing assets outside of their estates to avoid or partially avoid probate. Probate is basically court oversight of the estate administration process. In some Canadian provinces, such as Ontario and British Columbia, probate fees are based on the size of your estate. In Ontario, a $1 million estate would have probate fees of around $15,000. In such jurisdictions, there may be a financial interest in limiting the size of the estate that is subject to probate. In Alberta, probate fees are not currently based on the size of a person's estate. However, probate can be a lengthy process that often requires the assistance of lawyers and accountants. Minimizing or completely bypassing probate may allow beneficiaries to receive assets sooner while keeping costs down. Completely avoiding probate is not always possible or even desirable. That being said, there are often other reasons to distribute assets outside of a will. As mentioned earlier, a speedy distribution to beneficiaries is often desirable, and distributing assets through a will is not always quick or easy, regardless of whether probate is required. Another big reason to distribute assets outside of a will is to allow for quick sale of property, such as a family home, and to protect certain assets from possible creditors. Joint ownership is one of the most commonly used strategies for distributing assets outside of a will. When something is jointly owned, a principle known as the right of survivorship applies. If two people own property jointly and one person dies, the survivor becomes the sole owner of the property. This is the case regardless of whether the deceased person had a will. However, just because two people own property together doesn't mean that they own it jointly. For example, when two people own a piece of real estate together, it might be joint ownership, or it might be another form of ownership known as tenancy in common, or it might even be owned through some other method of ownership, such as a trust or corporation. Joint ownership is quite common for spouses and common law partners. It is less common for siblings, friends and acquaintances, and business partners. Insurance policies typically list actual human beneficiaries rather than estates. This has a couple of benefits. It means that a beneficiary can receive insurance funds quickly and with minimal hassle, at least in theory. It also means that funds will go to beneficiaries even if an estate has more debts than assets, so as to shield beneficiaries from potential creditors. Because of this, insurance can be an important part of estate planning for young families who have significant debts, such as student loans and lines of credit, and little by way of assets. Nowadays, a number of investment products may have beneficiaries directly listed. This is common for tax-free savings accounts and registered retirement savings plans. A gift made while a person is still alive is known as an inter vivos gift. If you are still alive and mentally competent, you can give gifts to people who may or may not already be included in your will. This may be one way, for example, of giving away personal items of sentimental value. Some people will place their assets in family trusts. Historically, some preferential tax treatment was given to certain trusts, but I gather that many of those tax advantages no longer exist. However, there may be other reasons to set up a trust, such as to shield certain assets from potential lawsuits or to provide financial protections to disabled family members. Please check out my upcoming video in which I will talk about how your estate can be described and defined in your will. If you enjoyed this video, please feel free to like it or share it or subscribe to my channel. If you have a question, please leave it in the comments section and I will do my best to respond. While I don't want to give specific legal advice in the comments section, I will try my best to answer general questions, provided it is understood that my responses to comments should not be taken as legal advice, that social media interactions are not considered lawyer-client interactions, and that your safest course of action is to consult directly with me or another lawyer if you have a legal issue or would like to prepare a will. Thank you.